I call Chris Farfoy.
Thank you very much, Mr Chair. Mr Chair, the title and commencement debates for bills are usually an opportunity for members of Parliament to take some licence and have some fun with titles of bills. But in this instance, Mr Chair, I'm certainly not going to do that because this is simply not a funny issue at all. And to do that would be belittling the effect of what this bill is having in our communities. It is a serious issue, and as it stands, I believe the title of the bill is the legal assistance, and the word sustainability has been struck out by the Select Committee Amendment Bill. And the question has to be asked why, and I've commended the Select Committee for making such changes, why the Select Committee thought it fit to remove one word from the title, that being sustainability. And wanting to be accurate, the Chair has given me the short borrowing ability of his dictionary, and under, it doesn't exactly have sustainability, but under sustain, it does describe it as, one of the descriptions, as to provide for or give support to, especially by supplying necessities. And therein lies the reason why this Select Committee has taken out the word sustainability from the title of the bill, because, Mr Chair, this certainly does not provide for or give support to, especially by supplying the necessities, to the legal assistance arena of our justice system. In fact, we would argue that it does exactly the opposite of that by taking away support for and not supplying the necessities for legal assistance, especially for our most vulnerable families. And Mr Chair, as Andrew Little argued, we don't want to get to the stage where access to justice and the ability to go through the justice system, whether it be a civil matter or a criminal matter, is all based on how much money you have in your bank account. And we believe that the motivation for this bill is simply fiscal, and that is to cut costs. And unfortunately, one of the effects of that is, as we fear, the access to justice for many New Zealanders will be removed. So we don't believe, and looking at the dictionary here, we actually think that the Select Committee was right to remove the sustainability word out of the title, because this bill does not provide it any support, and it does certainly not provide the legal assistance arena with the necessities to do what we believe the legal assistance provisions in our justice system are there to do. We do think it does exactly the opposite. We need to think of this from three different perspectives, Mr Chair. One is, as I've mentioned before, is the perspective of the child, and there are no words in the title at the moment that I can see that point towards being in the best interests of the child, neither in the explanatory note, Mr Chair, and that was a point that was made by the Children's Commissioner, who, if I can take the liberty to take some quotes out of his submission to the Select Committee, made a number of very good points. He did say that he noted that the bill made no reference to the best interests of the child in the explanatory note, despite the fact that this bill will clearly impact children and young people who are involved in family or youth court proceedings. He went on to say, Mr Chair, that these children and young people are among the most vulnerable in our community, and it is therefore imperative that their interests are given primary consideration. And you can't argue with the Children's Commissioner with that, Mr Chair, and if you think, being the primary advocate for children in our government setup, that he is purely focused on that. But as we can see, as I've referenced before, there's no explanation, or there's no reference to children in either the explanatory note or the title. The recommendations that the Children's Commissioner made were to basically not to proceed with this bill, Mr Chair. And his recommendations were that the bill is amended to expressly provide for the continuation of the current court-administered selection processes, and also basically he thought that the the access to justice and the provisions there for the best interests of the children, Mr Chair, were certainly not in the best interests of Mr Chair.
Chris Farfoy.
Not there for the best interests of the children. There are other pieces of legislation that are going through this House that we also think are down to cost-cutting, Mr Chair, and that is one that has been on the order paper earlier today. And I do want to read a quote there from Mark Hennigan from Otago University. And this is going back to working in the best interests of the children, Mr Chair, because Professor Mark Hennigan expressed his feelings in a very concise quote around the removal of child advocates, and this is certainly something that is covered in this bill. And he said, so a very quick quote, "If you take their representation out, then we doom them not to be heard." And in essence, if we do make the barriers much higher for families to access justice, which is what we're doing here in the Legal Assistance Amendment Bill, I think that Mr Hennigan's quote there becomes quite apt because it is, as Mr Little said, we believe one of the effects of this bill is there will be fewer child advocate councils being able to be accessed by families, and we do think that is of major concern to a lot of communities. Certainly, as I've mentioned, in my community in Porirua, the legal fraternity is very worried. Family lawyers are very worried about their ability to be able to act on families that they've had a relationship with for many, many years. I think they're a bit frustrated that some of the commentary that came back in their direction when they were opposing the moves that the government is making is that the lawyers were certainly trying to keep the gravy train going, that they were only concerned about the fees that could be gotten out of prolonging what is already in place or taking away any legal assistance that might be open to them. There was a deep level of frustration at that, Mr Chair, and I think that is well founded, because I think if you go to most communities around New Zealand and you talk to lawyers who are acting in family court proceedings or family proceedings, they very much have the interests of children and families at heart. I'm sure some of them also need to eat, and so they want to make sure that they get paid, but the insinuation that these lawyers were basically out trying to look after themselves was something that certainly upset them from the government. Mr Chair, as I said, this is not one of those title and commencement debates where you have fun with the title of the bill or with the commencement of the bill. Not that I'm thinking that anyone's ever had any fun talking about the commencement of a bill. But this is a serious issue. I note that the word sustainability has been removed from the bill. I have noted that this dictionary that has been loaned to me momentarily talks about sustainability being the ability to provide for or give support to, especially by supplying the necessities. We don't believe that this bill does that to the legal aid framework. We believe it does the exact opposite. It is appropriate that that word sustainability was removed from the title. Maybe the government shouldn't have put it in there in the first place and has been exposed for that. We don't believe that it is it does make the legal aid framework sustainable. We think it takes away the rights for many, many New Zealanders to access justice, especially the most vulnerable, and especially on this side of the House, we do not want to get to the stage where access to justice depends on whether you can afford it or not, Mr Chair.
The Honourable Leanne Dalzell.
Chairman, I'd like to